Yeah. So good evening or good afternoon, everyone. Welcome to this second webinar of the CCLS Distance Learning TMT Alumni chapter. And thank you for joining us today. As you already may know, the Alumni chapter organizes online events to allow the former students of the CCLS Distance Learning postgraduate programs to keep in touch and to express their voices in the TMT field. In this regard, the Alumni chapter supports all alumni who are willing to contribute to any event, whose attendance is certainly also open to current students of the CCLS postgraduate programs and everyone who has an interest in the interplay between technology, media, telecommunications, and the law. So please feel free to reach out to me or Catherine Taylor-Bennett or Rachel Ovuzudom if you'd like to participate as speaker in a webinar. Today, we will talk about international data transfers, as the webinar's title suggests. And by way of very quick introduction, I'm Valentina Torelli, a CCLS alumni, an Italian qualified data lawyer, and I'm extremely excited to present the outstanding speakers of our webinar. I am very thankful to my former coursemate Debbie Evans and Professor Flanagan for their availability in the organization of this webinar. Debbie Evans is a UK barrister and works as managing director within FTI's consulting practice in the EMEA region. She's an experienced DPO and has worked for a range of organizations in different sectors, delivering data protection programs to over 84 countries. Among others, she boasts an extensive experience in the implementation of data protection governance controls and frameworks, and she holds several certifications, such as the IAPP Fellow of Information Privacy, the Certified Information Privacy Manager, the Certified Information Privacy Professional. Professor Anne Flanagan maybe doesn't need any introduction, but you may already well know her as she's a member of the Center for Commercial Law Studies. She teaches distance learning courses in privacy and data protection law and European communications law, besides being a New York State licensed attorney. But before joining the Queen Mary University of London, she practiced law for 16 years as an associate with the law firm of Wilson, Elser, and Moskowitz, and Dicker in New York, and the US financial services industry. And among her varied functions, she served as a senior counsel at one of the largest, or maybe the world's largest, private pension system, that is the TIAA-CREF. Now, just a few housekeeping points for today. This webinar is going to be recorded, and the recording will be shared on the LinkedIn official pages of the CCLS, such as the LinkedIn group about the distance learning chapter TMT, the technology, media, telecommunications LLM group, or the alumni group. This is meant to be a dynamic webinar, so after the presentations of our speakers, we will have a Q&A session, and please submit any question, any request for clarification in the Q&A box below. And I will direct the questions to either Debbie or Anne. Now, my brief introduction is concluded, and without further ado, I'll leave the floor to Debbie, who will start talking about the legal and practical implications of cross-border data flows. Thank you, Debbie. The floor is yours.
Thank you, Valentina, and I hope I'm sharing my screen. Could you just nod?
Yes, you do. Yes, you do.
Good, good. Let me just put it onto full slideshow. Sorry. Right, well, thank you very much for allowing me to have some time to talk about this topic, which has, as a practicing data protection officer, ex-lawyer, etc., and somebody who helps many companies who operate globally, given me a little bit of a headache, and certainly given some of my clients a bit of headache. However, it doesn't have to be that way, but you know, these things are sent to try us, as they say. So what I hope to do on the session today, obviously you've had the introduction about me, but I'll just talk a little bit briefly about my practical experience in this space, talk about the purposes of the data transfer cross-border controls, the journey, and it can be a journey, it can be a hard journey, the mechanisms, the EU and the UK one specifically. I will maybe touch on some others, but predominantly that's my focus. Challenges, practical challenges, and some considerations that are worth thinking about when you do get involved in this sorts of work, or if you already are involved in this sort of work, hopefully some tips to help you along the way. And then I'll touch briefly on the EU US data privacy framework. This will be covered in more detail, I think, later on as well. And then I'll touch lightly on a bit of case law, but I really don't want to delve into that. And there'll be a useful checklist, and then I will give you my future vision or not, because I'm not really a psychic and I can't really predict the future, but we'll see. So yes, as Valentina said, I've had over 20 plus years experience in the data protection space. I started off many years ago as a barrister, mainly criminal, but I ended up going into computer crime and surveillance because that's an area that I was very interested in. And that led into a career in security and consultancy, working for various organizations, advising them on how to implement best practice controls from a data protection perspective and a security point of view. So had some great work, which I can't talk about on this session, but I'm happy to talk about that with people if they want to reach out to me. And currently I work for FTI as a consultant, where again, I help many global companies implement the requirements of data protection, and obviously data transfers is one of those areas that they need help with. So, right, okay, so what's the purposes of this session? Sharing personal data is not a new thing. You know, you want to book a holiday in a nice location somewhere overseas, you might try and do it yourself, or you might go through an agency, for example. So it's fairly normal to, you know, to share your data. And obviously, we buy things from overseas, people like to trade overseas, so it's not uncommon for details to be passed back and forth to various businesses. Or if you have, for example, a global operation, you might have a HR department in one part of the world, you might have IT support in another country, and you know, there might be good reasons for that. It obviously can save money because you might have more qualified people in certain jurisdictions, or you might have access to more resources in certain places. So companies often will make use of global resources. It saves money, it makes the best use of available resources. And obviously there's technology as well that you can leverage, and that may be hosted in different jurisdictions as well for whatever reason. Typically companies will try and have options. If they're very risk averse, they'll have maybe access to services where data is hosted in maybe the US, but also data may be hosted in EU countries. And now I'm seeing more data being hosted in the APAC region as well. So it does help organizations comply with their own standards. It also can help as a business resilience thing. So it is something that we see more and more. And clearly as well, sharing data globally is helpful for health challenges. We all know about that. We've all been very aware of all the issues with, you know, pandemics. And, you know, obviously countries and governments want to make sure that people, you know, if they are traveling, have got the right health boxes, health ticks, health conditions ticked, or vaccinations, whatever. So again, you know, that happens. And something that I was kind of familiar with was, you know, global intelligence as well. So obviously people, if they're trying to investigate international crimes, will want to be able to get access to or share data with equivalent criminal investigations organizations. And again, you know, there's interests of the whole, you know, it's in the interest of everybody that you track down certain criminals, particularly if they're really bad, obviously. So sharing data is not always a bad thing. And as I said, you know, we want to go on holiday, we need to tell people that we're arriving. So that's a pretty important thing in my book. And so hopefully what we're going to do today is just give you some, hints and tips about how practically you can think about this. Now, I firstly have to apologise. This is my own artwork. I didn't study art at school, obviously, but the reason I do things like this, I'm quite a visual person, and I think it helps to understand global data transfers or sharing as a, pictorially. And so how I often explain this to people is there's lots of hurdles, there's lots of things you've got to overcome, but obviously there are benefits with this as well. And so fundamentally, some of the key features of a global data sharing journey are listed on this page. And one thing is obviously you've got to make sure you know who's responsible for sharing data. Now, as an individual, if I want to go and book a holiday and deal directly, for example, with a hotel in another country, I can just potentially pick up the phone, give them my details, that's fine. But when you've got companies who are managing your data, you want to make sure, and they're maybe based in the country that you live in or based wherever, you want to make sure that you can trust them to actually look after your data and treat it with the level of respect and security, etc., as you would expect, depending on the data you're sharing with them. And so what's really important is that companies, when they do use a supplier or third party, for example, that they do the right level of checks, that they make sure that those third parties can be trusted. And that's represented here by some very dodgily drawn robots, green, amber, red, and you probably can't see it here. But basically, have you checked that the third parties that you're dealing with have got a suitable level of technical and organizational controls implemented that provides you with the confidence that not only do they understand their responsibilities, but they take them seriously and they'll communicate with you if something goes wrong. And so therefore, typically you'd expect the contracts, for example, to have those roles and responsibilities and those requirements covered, and the respective parties' data sharing requirements, etc., when it comes to those relationships. And I would sometimes want to see that those things that people say in a contract can be backed up by controls. And so more often than not, it's sensible to do a more detailed assessment of a third party, maybe to check, for example, that they have policies in place that govern security, that they understand how to manage breaches, that they understand the need to train staff, for example, and generally they operate with the right level right standard of security, depending on the type of personal data they may be receiving or processing on behalf of an organization that I'm looking after. And when it comes to transparency, I think we all know, and that's my person, with the little megaphone, we will keep you informed. It's absolutely important, or essential, in fact, that individuals know and understand how their data will be processed, accessed, managed, etc. Countries vary in terms of the requirements around notification. Generally in the UK, in the EU, we'd expect to be told in a pretty comprehensive, pretty clear, easily accessible manner. So we wouldn't expect it to be like reading a 100-page thesis. We'd expect it to be appropriate to the audience. And this is where some companies run into challenges, because if the audience are, say, I'm going to say minors, or people maybe not in a business environment, they may need things explained in a more easily accessible way. And this lends itself nicely then to rights, because obviously individuals have certain rights in relation to their data. In the EU and in the UK, it's very clear what our rights are, and there are several of those, and I'm sure most of you know what those are. But you have to still check whether those rights apply when data is shared, understand the purposes of the transfer, understand the reasons for that transfer. Because, for example, if the legal basis for sharing that data is, I'm going to say, health concerns, so to protect somebody's vital interest, they obviously need to have that data transferred to save somebody's life, for example. And lawful basis is something that people do need to consider quite carefully when they are transferring data overseas, particularly with sensitive data, because you sometimes need to consider whether you've got the right lawful basis, whether you need consent, etc. And you need to think about how that is demonstrated, captured, and applied. And what's very important as well, and people obviously need to be doing this or should be doing this now, is keeping what's called records of processing activities and evidence of, for example, transfer impact assessments or other sorts of risk assessments they've done. And so ideally, people should have either a tool that captures this to show the data flow, so it's very obvious to any regulators or auditors that where your data's come from, where it's going to, who will have access to it, etc. So having very clear, well-defined, well-managed records is one of the day-to-day things that anybody in a data privacy role should be keeping an eye on. And obviously the laws. It goes without saying, if you're going to transfer personal data to a certain country, first thing you should be thinking about is what laws have they got in place? Are they obviously adequate? If they're not adequate, what level of scrutiny do you need to go down to make sure that if you do share certain types of data, personal data, that you're not going to run into any risks? And risk management obviously is pretty fundamental to this whole personal data transfer issue. And we do need to make sure that not only do we routinely check the risks associated with the countries, we also check whether there is a need to continue to transfer certain types of data, or whether there's options to maybe just process data locally. And a couple of my next points. So data management. The other thing, if you are going to start sharing data overseas, who's responsible for keeping that up to date, making sure it's accurate, making sure that if it's no longer needed, it is deleted. Has that been covered off? Typically, that should be covered off in a contract if you're sharing data with a third party. But if this is something that's in an internal sharing of data, again, you'd need to make sure you've got the right details in any data retention policies or procedures. Right. So the mechanisms. So in the EU, and the UK is slightly different, but not massively. In the EU, personal data transfers are obviously subject to the GDPR. And in terms of terminology, when somebody from the EU shares data outside the European Economic Area, and they share it to a different country, that country is known as the third country. And they're known as the third country because they're not part of the EEA, so that's slightly different. And the European Commissioner says that basically you have to make sure a third country has adequate level of protection for the data subjects' rights and freedoms. And so there's a number of countries that have been deemed adequate. If you weren't aware of those, obviously you can look those up, but you can also see them jotted down here. This list does change. Countries do get added. This was current as of when I last put these slides together. So these hopefully are as current as they can be. So if a country is not declared adequate, then they have to basically, if you want to make a transfer, you have to make sure they've got appropriate safeguards in place when you're sharing data to a particular business in a non-adequate country. And what that means is you have to have in place what are called standard contract clauses. People in the industry just say SCCs because it's quite a mouthful to say standard contract clauses. And those are terms that have been approved by the European Commission, and they're used to make sure that people have in place the right contract terms when they are sharing personal data. And it does reference, the EC does reference other applicable supplementary measures as well. And this is where, you should put in place potentially more rigorous security controls. And you can get to that by doing something known as a transfer impact assessment. Excuse me. Now, there are other mechanisms the EC has said you could use, but these don't often, these are a bit harder to get. And so basically you could use something known as binding corporate rules, or you could have, you could rely on some sort of codes of conduct. And there are now certification mechanisms that you could use that might help you validate whether your transfer is safe and suitable from an EU regulatory perspective. The other way you can actually share data is if you've got what's known as a derogation, or basically an exemption. And I'll touch on those in a minute, but those are things, those are like the special reasons why you can transfer data. So, usually it's for good cause, etc. But I'll touch on that now. From an a UK perspective, obviously Brexit caused a bit of a bit of fun for the UK, because they wanted to do things slightly differently, and yes, they have. So whilst we still align with GDPR, we've decided for some reason, but no, there is a good reason. So they've come out with something known as the International Data Transfer Agreement instead of the, they still will use the SCCs if you're a global company. But if you're just going to share data from the UK, for example, to maybe the US, you could just use the International Data Transfer Agreement if you wanted to. But typically, companies will use a combination of the SCCs and an addendum to the UK IDTA, because it's just more comprehensive. Obviously, again, the UK has allowed for companies to put in place binding corporate rules, and typically these are used where you're sharing data between each other. You're a global organization and you want to share data with your relative company in another part of the world. It can be used in different reasons as well, but that's where I've seen it more commonly used. And the UK, instead of having what's called a transfer impact assessment, they've called it a transfer risk assessment, right? So again, they just want to create their own version of it. But I mean, it kind of does the same thing, slightly different format. And also the UK has their exemptions as well. And I will touch on these. Right, so the exceptions. So if you're not aware of these, basically have a look. It's worth understanding them. Not going to go into too much detail on this, but if you want to share data, and I probably explained this incorrectly slightly earlier, if there's a real emergency, yes, here, somebody is in a coma in the US, etc., and they're British, obviously, the US doctor has a good reason to get any medical history from people who have maybe been doctors for that person in the UK, right? Because that could save his or her life. So that sort of stuff, nobody's going to say, have you got a lawful basis? They're going to say, give me that data now, because this person, is in a flipping coma. It would be silly to stop that. And so obviously one-off transfers as well. You're not going to expect somebody to do a transfer impact assessment if you've just gone online and bought something from the US and they need to know your address. I mean, I don't know, and they're not trading typically. I think you've got to consider the necessity, the proportionality around this stuff. And what I would be very careful of, I mean, obviously, this is something that if you're in a business of regularly sharing data to a certain part of the world, you're probably not going to fall within this exemption. Yeah. Right. So what's caused all the hoo-ha about these transfer impact assessments and these, I'm going to say transfer risk assessments. So Max Schrems, who, is very passionate about transfers because he's a big, supporter of people's rights when it comes to data protection, has battled many times now to challenge the transfer regime between the EU and the US. And as a result of extensive legal debate, basically it was decided that the original EU-US privacy shield was invalid. There were concerns that the US weren't respecting people's rights when it came to surveillance, that they didn't recognize the rights of citizens other than US citizens. So this is something that had, got some weight in court, and consequently the EU ruled that companies, organizations needed to do more thorough risk assessments before making a transfer. hence the transfer impact assessment. And so basically, and these are the steps, and they're quite simple, or at least they seem simple. What you need to do before you start sharing data is understand, where the data is going to, why it's needed, etc. Do what's known as a data map. Where's the data originating from? Who's going to have access to it? It's part of the sort of records of processing activity step. And so if you do get involved in doing what's called ROPers, you would typically ask people what sort of data they're collecting, the purposes, who would go to, who would have access to it, etc. Once you've done that initial stage, you should then have a good idea about what transfer tool would be appropriate. Can you rely on an adequacy decision, for example? Is this something that needs SCCs? And then you would have to have a look at the laws and surveillance practices of the country that you're looking to share the data with. Do they have the same respect of individual rights as the EU, UK do? Have the government got extensive powers when it comes to trying to access data? All of these things need to be assessed in detail, and there's quite a few different laws you'd have to consider depending on the country. For example, cybersecurity laws, government's rights, etc. And then you'd need to think about the sort of safeguards that you need to think about put in place as a result of that. So, for example, do you need to be notified if somebody like a government wants access to your data? Do you need to maybe only give some data? Do you need to reconsider whether that transfer is needed? All of those things need to be thought about, and also obviously providing notice to the individuals as part of the implementation of any measures. And then you would constantly review it, because laws do change, and people need to be kept up to date with what is going on in this space. From a UK perspective, it's pretty similar, actually. Again, you have to complete a transfer risk assessment. Typically, what companies do, rather than do one for the UK, one for the EU, they usually look to just do one, and it'll cover both, both the EU and the UK, because otherwise you could have similar form, too many different forms, and people don't need to be burdened with that extra admin. So as long as they've got an assessment that covers the requirements of both jurisdictions, they should be fine. Right, so what are the challenges? Well, as I said, you've got the EU, you've got the UK. I mean, they've got their different languages, they've got the different variations. How do you accommodate all these different requirements? And you've also got other countries as well, like China, all sorts of other countries all over the world are in fact, so lots of countries are now considering the issue of sharing your citizens' data overseas, because there are huge risks with that, right? There's risks to national security, there's risks to abuse of, the individual's rights, etc. So how do you reconcile which to choose? So typically I would go for the highest standard, because I think that's the safest option, and try and make sure organizations do risk assessments that accommodate, the countries or the jurisdictions that have the highest standard, particularly if I operate globally. That way, then I don't miss something. If, though, you operate in a small jurisdictional space, obviously you don't have to look at the highest standard if you're not dealing with that jurisdiction, but just be mindful that some countries have higher standards, higher fines, and maybe tougher regulators. And how do organizations know when they have done enough? Good question. I never feel I've done enough. I could always do more, and I think you should always challenge yourself wherever you are, even if you think you're very good. You can always improve. You might have the best system in the world, and if you do, fantastic. I'd love to hear about it. But generally, these things can be challenging. Not only have you got to make sure that you're accommodating maybe business requirements, you need to make sure you truly understand how the legal landscape is evolving. and and basically try and make sure you've got the right administrative systems in place, that people understand what they need to do, things get escalated to you at the right time, depending on your role, of course, or just keep up to date with how things are being operationally dealt with. And there's, when it comes to the resources and the approach, a lot of companies or a lot of organizations, sorry, that I come across, sometimes maybe they don't do these that often. So it may be an ad hoc thing. So they do it maybe a couple of times a year, forget about it, and then think, oh, crikey, we've got to do this again. So there is a challenge with organizations, especially the smaller ones, maybe who don't share data overseas a lot, is that they don't routinely stay on top of this legal area, particularly if they don't have experts in the company. So that is something to be mindful of. And depending on what you guys go into or where you're working, you might have seen this as well yourselves. And as I said, I think I've said already, it's not just data protection, cyber security is something that you need to think about as well. Sometimes the data transfers and some other laws as well, because, countries do treat data in different ways depending on where you are. So this is quite a small slide, sorry. But what hopefully this does show, and this was taken from the IAPP, hopefully some of you are members there. But what this does show is that there is a number of countries globally now that have, have more stringent data privacy requirements, and they are obviously assessing their own sort of adequate standards and having their own approach to that. And equally, there are now a number of countries as well who have their own template or equivalent of, like, the standard contract clauses. So again, countries more so now want to make sure that the right standard of contract terms, etc., applies when their citizens' data is being shared to another jurisdiction. So in summary, some of the considerations that you need to think about, and hopefully this is useful practical stuff, is if you are considering an international transfer of data, have you done some form of assessment? Ideally, you'll have some templates that you can use, or some sort of form that you can send out to people, get them to fill it in if you don't know enough about the activity yourself. And often, if you're in a privacy role, you might question and challenge whether the transfer is necessary. You will also look at the reasons, the purposes for the transfer, and maybe explore whether the purposes are justifiable, and how they're going to communicate that intended transfer to individuals, and is it clear? And again, I think I said earlier, depending on the audience, you might have to adapt the language of your privacy notice, for example, or any additional communication you might send to individuals. And then if you are going to share data with third parties, as I mentioned before, if you've got the right contract terms in place, are you comfortable that they've got the right controls, the right level of detail in any policies they may have? Excuse me. Are you satisfied that their security standards are up to your standards? Have your security team maybe been involved to help review it if you're not technically sure? And again, is it clear what data is actually going to be transferred? And I keep saying this, this minimization point is, do you need to share all that data? Sometimes you don't. I find that a lot, that people overshare. I'm an oversharer sometimes, but you need to make sure you don't do that, and you share only what is really needed for the purposes of processing. And and think about where the data is coming from. It's sometimes helpful in a company, and hopefully some of you are familiar with the idea of privacy by design. And so it is helpful to really understand, and think about where data is coming from, and the whole sort of data life cycle, and the mechanisms to protect that data, and to constantly review, how you're gathering it. If you're gathering it from an external source, can you do that? Are you doing that with the right lawful basis? If you're getting it directly, are you relying on consent? How easy is it to to get rid of that data if the consent, for example, is removed, what measures or processes exist to help with all of those issues that may come up. And if data is stored in another country, how easy is it to delete it? How safe is it? You know, what happens at the end? Is that covered in the contract? And can you guarantee that individuals' rights are safeguarded? This can be a challenge because, you know, maybe if the location where the data is held, maybe they're not very organized and suddenly they can't get access to the data if somebody wants to use their rely on their data access right. You know, has it been tested? It's maybe a good idea to trial these things with some dummy data or something before, you know, you let things actually be transferred. I've talked about security a lot. As you know, it's pretty important. And again, you know, I've said about making sure things are deleted properly as well. And again, that is very important. We don't want to be having lots of data held somewhere we forget about. So, excuse me. So there's other things to consider as well. If you are maybe a country operating either in the UK and you want to process data in the EU, and equally if you're outside of the UK, EU, again, you might want to think about things like whether you need an EU representative. Not going to dwell on that too much, but something to think about. And obviously as well, there's a new mechanism now. There's the US data privacy framework and the UK US data bridge. This looks scary, this slide, but if you want a copy of these, this is fine. This is the sort of example of all the various EU, UK contract mechanisms. So, for example, in the EU, with the standard contract clauses, they've broken it down now into modules. So, for example, if it's a controller-to-controller relationship or controller-to-processor, there's different sections in the SCCs that need to be filled out. So you don't have to fill the whole lot out. When you first, if you've not done one of these already before, if you're not familiar with these, it looks scarier than it really is to start with. And that's just a practical insight, sorry. But once you start looking at it, you get a feel for what ones you need. And then actually it's not that hard to fill in. But initially you might be a bit overwhelmed. And a lot of companies get quite intimidated if they've not been used to these before because of the amount of stuff that's in there. And what was supposed to be simple is not that simple for a new person starting out, but once you've done it, it's fine. The UK have tried to simplify it, but again, it's debatable whether it is really that simple. I know there are still thoughts around how they can simplify it further, but let's watch this space. But most companies now should have the new, because these EU standard contract clauses with these extra modules are were fairly new. And most companies now, if they are dealing with data transfers, they should have the new versions already implemented, as they should have the UK equivalent ones as well. So I suspect not everybody has, but these new versions of data transfer terms should be in place with all companies now going forward, the up-to-date ones. So what's the data privacy framework? So this is something that was introduced last year, and the intention was, again, it's sort of to replace the privacy seal, which before that was the safe harbor. You know, they keep doing this. So this was, again, another way of providing this bridge between EU and US data transfers. I'm a little bit cynical on this, but, you know, I'm not going to say it's that bad. But basically, if a US company is certified to the data privacy framework, then an EU company should feel more confident that that organization is actually taking privacy seriously. I think companies haven't rushed to do this yet. And I know that, you know, there are various stances or positions being taken to try and encourage that. And I hope it does happen, because obviously it has become problematic for companies in the EU, UK, trading that easily with the US, because, you know, you've got to get these contract terms in place, you've got to do all these transfer impact assessments, whilst you'll still need to have contract terms in place, the transfer impact assessment issue hopefully will be less of a problem if companies do go along the data privacy framework journey. And even if you do go down the data privacy framework journey, it's not that easy. It's not like you can just do it and say, hey, I want to join this framework. You do need to obviously get basically checked, I suppose. You need to do checked. You need to follow certain standards, right? So you need to make sure that you tell people that you're involved in this scheme, that you've got the right level of security in place, and you can demonstrate that. So ideally, you'd have a comprehensive security statement with the accompanying procedures, policies, etc. That you are in a position to apply the right lawful basis, give people some choice, and that, for example, again, you're not going to just process any old data. You're going to make sure you're processing data for the right reasons, etc. So there are a few, and obviously there's some extra ones here as well, making sure that people still have rights of access to data. And these are important, again, to show that companies recognise the importance of applying certain safeguards and controls when it comes to transfers of data to the US. Now, what I recommend that people do if they are interested in this is have a look at the supplemental principles that are required in relation to EU-US transfers. And so you can find these easily on the actual, hopefully if you get shared these slides, you can have a look at the links there and they'll take you straight away to the requirements in terms of self-certification, if an organization chooses to go that route. Sorry, I'm losing my voice, excuse me a sec. So in terms of the EU organizations, when it comes to this, this data privacy framework, any data controller in the EU still needs to make sure they've got a contract in place when they are looking to transfer personal data, even if you're certified to the data privacy framework. So it doesn't exempt you from that, but what it will do is obviously reduce maybe your requirement to demonstrate you've got the supplementary measures in place, because by virtue of being on the data privacy framework, you already have got the right measures in place. For US organizations, there may be benefits, right, to certifying to the data privacy framework, because it's a bit of a pain to set it up to start with. It's a bit of an administrative burden, but in theory, you should be doing those things anyway if you're taking data from EU, UK citizens. And it'll also help provide, I suppose, credibility and demonstrate that you can be a trusted organization if in the US. There's an equivalent mechanism with the UK US data bridge. And again, that aims to try and simplify transfers to the US. In terms of the impact of this to organizations, again, like the EU, if you are able to rely on any form of transfer bridge, it will help with, confirming that it's relatively safe to transfer certain data to the US. Yeah, and that's helpful, for example, in companies where they have international operations or different parts of their business operating, for example, the US. So there's been a little bit of case law around this. Meta is in the press a lot in relation to data protection, and recently last year, they were imposed a fine of 1.2 billion euros in relation to unlawful transfers of personal data to the US. Now, I'm not going to go into detail on this. This isn't one of the areas that I can talk about in detail. But if you click onto the link, you can find a bit more detail about the case, and things are evolving in all sorts of ways. And clearly, the data privacy framework is something that Meta have been looking at and they had been looking at SCCs, etc. I think where it ends up will be interesting, because obviously the outcome of cases like this can have a big impact on how this sort of activity is viewed and how much scrutiny is needed and how much organizations need to do to make sure they can comply with these requirements, particularly the transfer impact assessments and the assurance of having the right contracting mechanism in place or equivalent. So, okay, operational requirements in summary again. So what you need to do, very important, is make sure that if there is obviously a transfer, that it's clear who the importer is and the exporter is. That should be clear from the way information has either been sent out or taken in. Generally, you're obviously exporting it if you're giving the data to another country, and you're importing it if you're receiving it. And if you're the person giving the data away, the data exporter, you need to make sure you do a transfer impact assessment, or TRA if in the UK. And again, as I said before, that's basically about understanding the transfer, making sure you've got the right mechanism in place, the right tool. Again, assess the laws of the country, make sure you've got any additionally identified supplementary measures, for example, more robust security, and making sure it's up to the standard of the country that you're operating in. And if you think there's an acceptable level of risk, you document that, you keep that filed, and then that would be used then to support any transfer. And obviously you should check this on a routine basis, constantly review the transfers. And it's important for, from a checklist point of view, it's important to make sure people are constantly staying on top of the legal requirements, both in terms of the country you operate in, or in the countries that are going to be receiving the data, for example. Make sure you understand the risks, make sure that whatever mechanism is used, that you do, for example, continually review the third parties, that due diligence is conducted not just as a one-off thing, but you routinely check, the status of a particular maybe third party or country that you're sending data to, and keep a track of the type of data you're transferring to another country. Sometimes people will try and sneak in extra data, make sure they understand the risk associated with that, and they just don't start sharing extra bits of data because they think it's okay to do so without checking first with the appropriate compliance team. And make sure your organization understands the importance of security and taking the right level of measures to protect data, maybe pseudonymize it if they can, or make sure it's constantly cleaned up and access is limited to those who need to see it. Contracts, obviously, you need to make sure you have the appropriate contracts in place, and that again, those aren't just left in a drawer and forgotten about. You don't use drawers anymore, but left in a folder and forgotten about. But make sure people do constantly check they've got the right versions of contract terms in place. And it is a cycle. You've got to keep monitoring and checking that things have been up to date, and that, for example, there's no breaches or things haven't gone wrong. I mean, what would happen if there was a breach in the country where your data had gone to? How would you handle that? Have you got a process that governs that? Have people been trained on what to do if there's something that goes wrong? Do they know how to handle not only the sort of the crisis, but they know how to maybe tell people what's happened? Are they aware of the different requirements in the different jurisdictions? And be transparent, above all, not only to individuals, but obviously to regulators. But I think it's pretty fundamental that people understand what you're doing with their data, because then not only are you obviously exercising your legal requirements to do that, but you're keeping people informed. And if they've got any issues, then hopefully they can keep in touch. Right, final flash of the diagram. Hopefully that that sort of sums up some of the data journey challenges, the global data sharing journey challenges. There are a lot, And in this short period of time, even though I've spoken for ages and I'm losing my voice, there are a lot of things to consider, and each one of those could be an hour session on their own. So I've really only touched lightly on this just to sort of give you a flavour of some of the complexities. The future, I've had a crystal ball, which I don't. Who knows, right? We have the risk of Schrems 3, because people may want to challenge, the US data privacy framework. Who knows? It might be that will go in a better direction. Maybe there'll be more confidence about how the US actually, treat data. I'm not going to comment on that now. Global frameworks are starting to appear in certain sectors. Maybe you might start seeing certain sectors, maybe healthcare, maybe financial services, they may want to make sure they have some sort of code of conduct that allows a safe transfer of data and everyone's happy with it, and you don't need to do any more assessments. That's something that potentially could happen, and there has been discussion around that. Maybe more countries being deemed adequate. Maybe the UK not being deemed adequate. That's another risk. And obviously the UK's got bills they want to propose, trying to reduce the burden. But again, that could cause more fear with Europe, and hamper their chances of staying in the adequacy list. But all of these things are too difficult to predict, and I probably would bet on them, but not publicly. But interesting thoughts there for everyone to consider. If the slides are shared, there are some links here as well. I do recommend people sort of dip into those things just to expand their own knowledge, because you can't explain in this session everything. There's quite a lot of detail here. Hopefully that's been useful. I'm going to stop sharing my screen now and try and rest my voice for a minute. Thank you.
Thank you, Debbie. Yes, your slide can be shared for sure with the audience. And thank you very much for this comprehensive and super informative overview of international data transfer from the EU and UK perspective. So you have been talking about the legal requirements and the practical issues that companies, whether they have a worldwide presence or are simply located in the EU or in the UK, may face when transferring data outside the UK or the European Economic Area. And among the topics that you covered, there are the data transfer mechanism. Now, I'm very excited to listen to Anne, who will be provided us with the deep dive into the one of those mechanisms for the data transfer to the United States, which is maybe one of the most requested jurisdictions for practical, organizational, and technological reasons when it comes to data transfers, both for corporations which are globally active and for consumers acquiring services online. So, and the floor is yours now, and you can share your presentation. Thank you very much.
Valentina, thank you. Thank you for inviting me today. Let's see what we have here. Oh.
Do you need help in sharing the presentation?
Yeah, I think I might, because I'm working from a new computer.
Sure.
And
I'm gonna do that.
Wait one second. I think. Let's see, maybe it will do it now. I didn't test the share screen function.
No problem.
Okay, I think I got it.
Yeah, perfect. Great. Go ahead, please.
I thought I would focus on an aspect of the data privacy framework, which I think is important to understand in this post-Schrems environment for data transfers. So primarily, I'd like to look at today what changed, what did the US put in place as part of the negotiations under the data privacy framework. So I'm sure you'll recall that in Schrems 1 and Schrems 2, the Court of Justice of the European Union focused on, under the safe harbor, the weaknesses in the frameworks that had been put in place via a patchwork of negotiations with the US, and basically taking judicial notice, and to an extent, and relying on Commission communications that acknowledged the signals intelligence activities that were revealed in the Snowden revelations, that the intelligence agencies of the US, in many instances, particularly with the tech companies, had direct access in order to be able to engage in bulk collection of personal data as it was going across the wires or the pipes. And with the striking down in Schrems 2 of the Privacy Shield, it was clear that something more was needed, because the same weaknesses basically were in place. A failure to ensure that protections applied to EU citizens whose data was transferred, and meaningful redress mechanisms that allowed data subjects to enforce their rights. So we have the substantive elements and the procedural elements that combined for equivalent protection. So President Biden executed Executive Order 14086 on enhancing the safeguards for United States signals intelligence activities. And basically, the directive, the executive order here, makes it clear that signals intelligence can only be done pursuant to law, executive order, or other presidential directive with the impact of law. And that this has to be in compliance with the Constitution, executive orders, and other statutes. So it's approximating pursuant to law, in compliance with the law, and then adding in elements to ensure proportionality and necessity. So only where these activities are necessary to advance a validated intelligence priority, and with oversight by the Director of National Security Intelligence and different other parties, to ensure that these identified legitimate objectives are current and relevant and reviewed on an ongoing basis. And then this activity, this collection, use, storage, has to be access and storage has to be subject to safeguards for which privacy is an integral consideration. Now, the executive order lists the validated intelligence priorities and the legitimate activities. So there's a specific list, largely focused around, of course, national security, control of terrorism, safety of people. The order is it's worth reading to look at these priorities and understand what they're trying to achieve. Now, I think one of the key distinctions between the US approach and the EU approach to national security intelligence activities is that the US intelligence authorities are authorized to do bulk collection with the idea that, well, you can't find a needle in a haystack unless you have a haystack. And so they collect it and using the various mechanisms. And then the safeguards then usually come afterward for access and use, whereas the approach is different in the EU, where for bulk collection, you need the justification to ensure that this is proportionate and necessary to the situation. And so the executive order focuses on this aspect, and it specifies that bulk collection with regard to signal intelligence in the US will only take place where it's determined that it can't otherwise be reasonably obtained using a targeted collection approach. Okay, and that they have to establish in advance the methods and the evaluations for ensuring that this collection is limited to what's necessary to meet the legitimate objective and to minimize other data collection. So this is a review process that's been implemented to address the issue of the bulk collection. And then access and use of the signals and intelligence data that's collected is only be used for identified objectives, so the specific objectives, and then by persons who are trained in the use of the data and who have a need to know in order to achieve their mission. As well, there have to be policies and procedures for minimizing the dissemination of the data with and its retention. And in addressing these policies, setting these policies, the signal intelligence agencies, the intelligence community, is required to subject the data to the same rules and considerations as would apply to that being collected of US citizens. Now, there's also a requirement that all of these policies have to be updated and reviewed within 1 year of the implementation of the EO in order to implement its privacy safeguards. Now, these are to be reviewed by the Privacy and Civil Liberties Oversight Board, which is an independent agency that was created in the post-9/11 environment in order to oversee various surveillance activities. And then the executive order makes it a requirement, to the extent possible, these policies with their privacy safeguards are to be publicly released. And there's a security obligation imposed on the intelligence community for this personal data, and with an obligation to prevent access to it by non-authorized persons. And documentation, accountability is required. So reasonable documentation according to the various circumstances of the factual basis for the collection, okay, and the basis for the necessity to advance a valid intelligence priority. And then oversight is to take place at each intelligence community department agency, including the requirement to have in place an inspector general. Now, the inspector general role is kind of a general compliance auditor function. And so fiscal accountability, compliance with the laws generally. And so now this has been put under that umbrella as well. And they're each required to have compliance officers and privacy and civil liberties officers, okay? With the agencies required to foster their independence by taking no action to influence these officers in the exercise of these responsibilities. And the order requires that the intelligence community, every agency or department, train every single one of their employees that has access to signals intelligence with respect to the requirements of the law, of this executive order, and so that they are all have working familiarity with the security, privacy mechanisms and policies. An obligation is placed on each agency to report significant non-compliance incidents to the head of the agency or the department, as well as the Director of National Intelligence, who's got overarching responsibility. And then every agency has to be part of the signals intelligence redress mechanism under a procedure to process complaints that are transmitted by national authorities to data protection authorities. Basically, it's referred to as qualifying countries, and the Department of Justice, under the implementing regulation, has designated each EEA and EU country as a qualifying country for the processing of complaints. Now, the redress mechanism allows for, requires an investigation by the Civil Liberties Protection Officer of the Office of the Director for National Intelligence. And so that officer is required to engage in an independent investigation. He's required to have, he or she is required to have access to any necessary information that he needs in order to conduct that investigation, with the charge to, without disclosing the confidential, the secure information, that either the complaint was not found, or that the officer has ordered an appropriate remediation to take place. Now, the specific remediation that's been ordered is required by the executive order to be binding on the agency or department, subject only to a contrary determination by a data protection review court. Now, the data protection review court, so this would be the second layer of the redress mechanism that the executive order creates. So either the complainant or the particular agency of the intelligence community can appeal to this executive order. Attorney General created independent data protection review court. Okay. And for the purposes of the appeal, a special advocate will be appointed, and two have been designated by the Department of Justice to represent the complainant's interest. The Civil Liberties Protection Officer will file a classified report of its factual findings and the rationale for the remedy. And if the review court does not uphold that remedy, it can substitute a different remedy or finding of fact, and that has binding effect for the complaint. So that is a significant, if we think about it, this executive order seeks to put in place a whole range of limitations on the procedures and policies of the signals intelligence, the intelligence community, in order to identify and to establish necessity, proportionality, findings that bulk collection is needed in these scenarios, and then training, security obligations, contemporary records, and accountability, all in compliance with the executive order. Now, for private organizations that are seeking to take advantage of the data protection, data privacy framework, EU-US data privacy framework, I think they're going to find many similarities to the Privacy Shield, the earlier Safe Harbor. Basically, it remains a voluntary program whereby entities that are regulated by the Department of Transportation or the Federal Trade Commission can participate. Okay, and so that leaves out. So the Department of Transportation is basically airlines. The Federal Trade Commission does not encompass quite a number of financial services organizations that would be regulated, for example, by the SEC or another financial regulator. Insurance companies that are regulated by the states. And so it is a fairly limited, not fairly limited, many organizations fall under the Federal Trade Commission, who then will treat any infringement of the failure, any non-compliance with the principles and redress mechanisms to be an unfair or deceptive trade practice, because they have declared themselves, they've registered with the Department of Commerce, and declared themselves to be adherent to the data privacy framework. Now, At the Department of Commerce, the US Department of Commerce, there's a list of participants with the types of data that they're seeking to benefit from this framework. So it can be, non-human, non-HR data, HR data, and the listing provides the contact information, the redress mechanisms, a whole and as well policy statements, privacy policy statements. And as we saw in Debbie's presentation, there is compliance with a whole range of principles, notice, choice, and accountability, security. These are virtually unchanged from the earlier frameworks. Now, as with the prior frameworks, there is a private redress mechanism. However, we have additional layers here added in. So the process begins with a complaint by a data subject to the organization in question. And under the DPF, the organization has 45 days to respond to the complainant. And then if there is no response, the data subject is then to turn to the free of charge independent redress organization that's been identified in the Department of Commerce listing. And then there's also the possibility to complain to their national DPA. When that data protection authority receives the complaint, it can forward it to, there's a liaison officer who's been established at the Department of Commerce, and that can trigger a further investigation of 90 days in order to respond. All of these have to be opted for and are exploited before the complainant can seek binding arbitration as a final recourse. Now, contributions to maintain this arbitration recourse avenue are made according to revenue, annual revenues of each participating organization, up to a cap level of $10,000 a year. This mechanism and the other mechanisms have the possibility to impose individual specific non-monetary equitable relief, such as access, correction, deletion, or actually, this is the binding arbitration. The other mechanisms, the earlier mechanisms, could even provide for damages. But here, it's non-monetary equitable relief. So ordering that data be deleted, it be corrected, or that be returned to the individual in a manner that's necessary to remedy the violation of the principles only. There's also the possibility for the data subject to contact the US regulator. However, there's a big caveat in that regard, I think. The FTC on its own website under this program says that it really does not address individual complaints. The FTC's approach to regulation is to identify trends and take cases that will make the biggest impact, either by engaging with or examining the conduct of a significant entity, or examining Yeah, it's largely that. Sometimes it'll take an approach where it's looking at representative harms, things that are happening according to a trend. And this way, if it takes an action against one entity, others are put on notice. It just doesn't have the manpower in order to do individual complaints. It's never been the way it's worked. And as I've already noted, it does not have the authority to govern certain entities. So, some thoughts about this data privacy framework. Now, one of the concerns regarding the Privacy Shield was that some of the mechanisms that had been put in place were just voluntary mechanisms that were not legally enforceable. For example, the appointment of at the State Department of the representative, the ombudsman, let's call it. There was no legal enforceable basis for that. And some of the things were just by agreement of the agencies. So here we have an executive order, which is legally enforceable, okay? The legislature can't change the executive order, so Congress can't do anything about it, but these are subject to court challenge. And so they have to have the proper authority in place for the executive order to continue to be upheld. So it has to be grounded in Article 2 of the Constitution that describes the various roles of the president, the various hats. It has to be either grounded in that, or there has to be legislation on the books that allows for an exercise of power. And it can also be retroactively affirmed by congressional action. The primary issue, beyond the judicial challenge possibility, is that executive orders can be changed by a subsequent executive order. So they can be revoked, they can be amended. And so there's not a guarantee that the mechanism of an executive order is a permanent fix. And so, that throws, I think, a fairly significant shadow, a question mark, into its sustainability and perhaps the finding of its equivalence under EU law. Would a challenge be made by Schrems? And so I do think that the executive order has made a meaningful, good faith attempt to address the findings, the particular lacuna in the prior framework, but it still may prove ultimately a weakness. Now, the Data Protection Review Court, which is, I think, a considerable improvement, so it allows for an appeal. So it's a two-staged, meaningful, independent review, has been set up by the Attorney General within the offices of the Department of Justice. And if you, follow this link, you will go and you will see that the court has some heavy hitters, legally speaking, some long-term esteemed practitioners in the field. Eric Holder, the former Attorney General, James Baker, a range of people who have great expertise in the area. And as I already mentioned, we have the appointment of two also very experienced expert persons as the special advocates. So my view is that while it may be struck down, I think it's going to be harder to be struck down, but if it is upheld, it will benefit transfers to the US, not only under this data privacy framework, but also under any appropriate safeguards mechanism in in Chapter 5, Article 46. Because the reforms, the executive order is not limited to the data privacy framework. The reforms to the signal intelligence community are broader. They apply generally for this signals intelligence involving foreign persons. So the Meta case, so what we had in there, as Debbie mentioned, we had a complaint, and no, it was an own initiative investigation by the Irish Data Protection Commissioner. And looking at the transfer practices of Meta, both under the 2010 standard contractual clauses as well as the current set. And Meta had engaged in risk analysis and had put in place supplementary protections, which were made clear in Schrems 2 that the transferor had to put in place before they could utilize any mechanisms. That they had to analyze the legal risks, the level of protection in the country to which the data was being transferred. So despite Meta having done these, it was still found not to have sufficiently protected the data. And while the Data Protection Commissioner of Ireland would have merely suspended the transfers, the European Data Protection Board and various other concerned data protection authorities under the EU coordination and cooperation framework required in a binding decision that the Data Protection Commissioner of Ireland sanctioned Meta to the tune of the 1.2 billion euro. So I do believe that with the reforms that have occurred to the procedures and operations and the redress mechanisms of the signal intelligence community, I think the concerns that would underlie any controller looking to transfer data and analyzing the US access to it would be better met. And so I think Meta, had that been in place, it wouldn't have been in this position. However, clearly this does not address other non-adequate country transfer issues. So this individual country analysis and focus will still have to be done by controllers with respect to the other appropriate mechanisms. And I point out that, while perhaps the US has cleaned up its operations a bit, commentators, privacy analysts have noted that in this whole sharing of data and surveillance activities and bulk collection has been done among what are called the Five Eyes countries. So the UK, New Zealand, Australia, Canada, and the US. Clearly, New Zealand and Canada have adequacy decisions, and yet their surveillance activities and data sharing and collection have yet to be challenged. So it hasn't happened in all these years, but it doesn't mean it's not possible. And if we remember that under Schrems 1, the court basically called the DPA of Ireland into account and noted that it was charged with its duty. It had failed in its duty to investigate the complaints and to bring the question before the courts if there was found to be a problem. So DPAs have to be proactive in this area. And so to the extent that new complaints are raised, they're going to have to address them, which, just puts us in the perhaps the same boat as we were before, perhaps with less risk on the US data privacy framework due to what I view as some substantial reforms, but clearly it's not perfect yet. So I'm gonna leave off there, and
Thank you, Anne, for this very useful, clear, and detailed insight into the executive order 14086, which is at the basis of the European Commission's adequacy decision under the data privacy framework. And I found particularly interesting what you said about the redress mechanism, and I was wondering, and maybe you may address it later. I was wondering if this new redress mechanism can be found effective or burdensome by data subjects who are located here in the European Union. And the second aspect, likewise, interesting, is the possible instability of the data of the executive order, and therefore the possible consequences for the data privacy framework. I've seen organizations in data transfer agreements, including clauses related to a fallback position in case the data privacy framework is declared null and void again, not again, but also declared null and void, in order for other mechanisms which were detailed and described by Debbie can be put in place immediately afterwards in order to continue the data transfer. But at this stage, we have questions, and I'm very happy because this means that your presentations were well welcomed and interesting. The first, and I posed the questions to both of you, and you decide who go first. The first question asks, what is the cost differential between multinational companies and small, medium enterprises in respect of compliance costs? That means in terms of cost to comply with data transfer mechanisms and rules. What are the differences if you are a multinational or you are a small, medium enterprise?
Debbie, you want to handle that
Yeah,
one?
that's quite a hard question.
I think just, basically the EU has said, we recognize that there might be, but we can't care about that because this is a human right. And so the only place they gave them any relief was in, a derogation for SMEs of 250 employees and below with revenues of under 50 million, not to do record keeping. Yet you're crazy if you're a company that doesn't do record keeping, because how are you going to defend yourself? So I don't know, maybe you have further insights.
Yeah, and I think this is the challenge, because it doesn't matter how small you are. I say how small you are, obviously, if you could argue that you're so small that it just wouldn't be even, you couldn't even undertake a business. I think you do need to put in place the right safeguards. If you're going to operate globally, you've got to behave like a global company and operate responsibly. And so whether that means outsourcing and getting some experts to help you, or whether that means employing the right people or just training people internally, you do need to do this properly. And you can't ignore the admin side. People hate admin, sorry, but you have to do the right data, as Anne said.
Yeah.
You know, if you don't know where your data is coming from, if you try and ignore some basic stuff, you're never going to be able to do this properly. So
most of it can be done by effective oversight and management with really well done policies, with clearly assigned roles and procedures. You might need to bring in, well, people hate to pay for lawyers and particularly
and consultants, sorry.
and and consultants, but sometimes the expertise can save so much money down the line that it's worth it. The ICO makes it clear that that you don't need all the technical bells and whistles. You just have to ensure that you've got in place procedures and technology that's designed to meet the need, and it can be cost-effective technology. So yeah, I mean, it is a cost point, but I think it can be managed.
Yeah, and I think these days, and going to your point about the cost of the technologies, there are cheaper versions of everything, right? Nobody needs the Ferrari. You can buy the Mini or whatever the cheaper alternative is, as long as it functions in the right way and you know how to drive and you know how to use the technology or use the tools to provide the right levels of safeguards and controls. Then that's the best you can do. You've got to be responsible when you're dealing globally.
Well, even if you're not dealing globally, if you're processing large amounts of personal data, you have to be responsible for it, and you have to understand, the proper security mechanism. If we're talking even just about security alone, there are standards, and I'll call them the checklist standards, which offer guidance and to less companies with fewer resources as to the core components of security and what you have to do to put it in place. So I think if you care, and you should care if you want your business to be ongoing, you need to avail yourselves of these kinds of resources.
Yeah, of course, and it very much depends on the reliance on personal data for any specific business model, and so the processes and procedures should be adequate to the extent of the processing. That's clear. Thank you very much, both. The second question is a little bit cryptic, in my opinion, but I will also try to interpret it. The participant asks if data transfer in blockchain may contradict the GDPR. So maybe it refers to the different types of blockchain and whether it's a centralized or decentralized model, or whether it's a private run blockchain, or is a public accessible blockchain. So I don't know, what are your thoughts on this question?
So what was the actual point they wanted to?
If data transfer in blockchain may contradict the GDPR and the rules, the principles in the GDPR.
They contradict, did you say? Sorry.
Yeah.
Yeah. So I don't want to get too excited about blockchain, because I have some different probably views to many people. I don't know, maybe I don't. But I still think the fundamental principles around GDPR need to be considered, whether it's blockchain or not. I think the challenges are understanding the start, the end, and the rest of it, because I'm not technically as insightful on how that mechanism works. But I think there still needs to be a level of responsibility. And even though the data might be located in various places, it's a bit, and if you know more about this, please chime in. But I don't think you can ignore GDPR just because of blockchain functionality and activities.
Yeah, I'm not truly expert in blockchain, but I get the sense that good faith efforts at compliance with the GDPR have satisfied the regulators in the use, and there's guidance. For example, the French regulator has put out guidance about its use, so it's a valuable mechanism. Again, I think with any technology, you don't take it up until you know what you're doing with it, and you've figured out, what really matters for compliance. That's all I got to say on blockchain.
Yeah, it's very complicated, and the fact that there could be different models of blockchain doesn't help to to provide a conclusive answer to the question. And there's another question which is very interesting because I think points to onward transfers. And the participant asked, if a company which is a processor is included in the data privacy framework, does this mean that the controller should not perform any other due diligence checks to see if potentially the processor further transfers the data to other countries besides the US? Meaning the data controller should perform checks about onward transfers if the processor, which is the data importer, is located in the US and is subject to the DPF, and then transfer the data outside the US to other jurisdictions not covered by an adequacy decision.
Yeah, so I'm going to just go with a yes, they should be checked. Sorry, straight in there. And if you want to say it in a much more
I agree.
way,
You're the controller. So this is a controller to a processor in the US.
The controller, I imagine, I'm interpreting the question. The controller is in the EU and the processor is in the US and is adherent to the DPF.
Yeah, you have to do your due diligence for all of your third parties stuff and you have to ensure that there are the proper further contracts in place, or you haven't done your job.
Yeah, and so possibly we may suggest that the data controller include clauses in the data transfer agreements with the data processor, even under the DPF, stating how the data processor should behave when it performs onboard transfers and transfer data outside the US, including support with the transfer impact assessment or transfer risk assessment under the UK law, I guess.
You wouldn't have the ability to comply properly with your transparency obligations and your notification obligations if you hadn't ascertained this, because all of that would need to be disclosed up front.
Sure. And there's another question. I'm very happy about it. The description of the US system sounds like it is inefficient, at least process-wise. What Anne's view of it?
That's for you, Anne.
Yeah. Are we talking about inefficiency in terms of time, or the fact that before you can get to binding arbitration, you have to go through those particular hoops? I mean, if we think about it, if it's working properly, it is very possible, you know, so they have to publish this information, they have to disclose their auditor, their compliance mechanism. Yeah, I agree. It is inefficient to have to go through those various steps. I'm assuming that's what's being asked. But I think you would have to do the same in the EU or the UK particularly. You would have to make a complaint to the company. The company would have a month to respond. Okay. And then before the ICO or the Data Protection Authority would accept a complaint. So in that regard, the timeframes aren't too different. But yeah, it is a bit inefficient until you get to binding arbitration. But we've seen processes, for example, the investigations under financial laws that require that process as well. So timeframes, different parties, different steps, showing that the data subject or the consumer had, you know, ticked all the buttons before it went to this particular body. In terms of the signals intelligence, that doesn't really sound that inefficient to me. Of course, it's government, so I don't know how, and we haven't really seen, well, I don't even know to what extent we will see decisions, because we're talking about the intelligence communities, but the idea that the complaint would go to this data protection officer, it would be investigated, a response would be given. I mean, that doesn't appear to me to be that inefficient, but of course, that's just my evaluation from the description of it. I haven't seen it in operation. I have a feeling, though, they're going to want to prove themselves that they can do this, that this can be a meaningful process, and that data subjects will have redress mechanisms both for government and private industry. So, and don't forget, this will be subject to a review in a couple of years. So if it isn't workable, efficient, providing meaningful redress, there's going to be adjustments to it or potentially problems.
Great. So you've also addressed my observation that I've made before in respect of the efficiency of the redress mechanism. So now I have a question for Debbie, if she can just outline the practical steps for effective transfer impact assessment or transfer risk assessment. So how the entities who are the data exporters need to approach practically these two additional safeguards for data transfers.
So I think, basically speaking, you need to have either a person or a team of people who understand the requirements and have documented and provided training to the wider applicable business stakeholders the requirements in terms of transfers. Sometimes there's a lack of knowledge, lack of awareness, there's no, you know, operational controls in place. So get something in place, make sure you've got people taking responsibility for it, and then make sure those people who aren't responsible for it understand the need to stay up to date with risks, etc. If they can't do it themselves, obviously seek outside help or plug in to useful websites or information resources that are out there. Obviously, it depends on the budget. And you know, and try and create maybe templates that will help as well. You know, if you know what jurisdictions, if you're an exporter, for example, think about the countries that you're exporting to, maybe do some initial work and research on those the countries that you might be going to make sure you understand the risks, etc. up front. You know, don't leave things to the last minute. Being prepared, planning, etc. in advance really helps, because one thing that businesses get quite frustrated about is the compliance police. And I say that with a sort of cheeky smile, because, you know, people always want to try and avoid, you know, burdensome controls and checklists if they can. So, you know, make it as easy for them as possible by doing a lot of the prep work, so that when things come up, you can have sensible conversations with whoever it may be, whether it's marketing, whether it's operations, and say, look, yeah, you know, we have to do this. We'll help you through it. And we just need to understand a few things. And then rather than push back on them, say, well, have you thought about doing things a certain way? So try and be as I try and be as helpful as possible, and try and make things seem seamless. I mean, there's a lot of work going on in the background from my perspective, potentially, but, you know, try and make business people not think it's a block. It's just a sensible way of doing business. And in a way, I try and present it that way, so they understand this is beneficial, not just for the business, but for, you know, people whose data is being shared. So, you know, think about it in a practical way and present it that way. Anything else, Anne? Sorry, I probably...
No, thank you. That's
No.
clear. Yeah. So I don't know whether either you, Anne, or Debbie want to add anything to the discussions that we have done so far. Otherwise, I think we can wrap up this webinar.
Just a quick one from me. I think if this is a new area for people, don't panic, deep breath. You're not going to be an expert overnight, and this stuff can be quite complicated. One of the questions around blockchain is particularly challenging, and there's always going to be new forms of technology, new ways of doing things that are going to leave people pondering, you know, how they should and shouldn't do it. I think a degree of common sense and putting yourself in the position of the individuals whose data has been transferred sometimes gives you, you know, you've got to think, well, how would I feel and what safeguards would I want? You know, I don't know, it depends where you're from in the world, but, you know, just think about things very carefully, be sensible about it, don't try and take shortcuts, and get expert advice if you're not sure. Yeah, that's sort of the sensible thing, I think, from my point of view. And thank you for listening as well.
Yeah, I agree with that. I think kind of maintaining your you have to have processes around things. You have to document, you have to think through things. And, you know, sure, everything's going to be a challenge the first time you do it. But if you've, you know, there's so many resources out there these days to and guidance for steps. I also think the regulators, often will let themselves give an unofficial advice or opinion. So I think, you know, don't be afraid to ask. Don't be afraid to, you know, breathe, take the time to plan it out, and you know, take as best common sense approach that you can to it.
Yes, thank you. So it's been wonderful. I thank you both very much for this valuable webinar and the content that you presented to me and to the audience. And I also thank all the participants who have been staying with us until late, or in any case have decided to join us for this event. And I think from us it's all.
Yeah.
And I wish you a pleasant evening ahead.
You too, and thank you for asking us, Valentine.
Thank you.
Thank you. Bye-bye.
Bye now.